All right. See if I can move this down quickly or more quickly than that. So last week we went through pretty much all the financing. We talked about closing costs, and I think we got to about right here. So the remainder of the contract will deal with inspections and disclosures. And again, let's start back with lines 144, 146, and 148, because we're going to dive into the inspections here in just a minute. But remember that those are three little buckets and they don't overflow into each other. They are separate amounts for repairs, general repairs, for wood destroying organisms, termites, and for permit costs. So you have to be careful based on your selling price to make sure you put enough money in there, or you could get into a situation where you have a $200,000 house and it's $3,000, and you have $6,000 in repairs. The seller in this contract is only obligated to repair up to the maximum that you put in these buckets. So even if you put more in there than you think you should, like 10,000, and the seller can counter it and say, no, I'm only going to pay 5, at least you have enough money in there to cover your repairs, because this is very definitely an upper limit on what the seller has to repair. So remember that as you're going through there. We talked a little bit last week about being able to do a net sheet using the TA Access One net sheet, or you can certainly Google seller net sheet or buyer net sheet on the internet and get a nice little workable format that you can put in all of the various costs, and you can produce a report for your buyer or seller that will differentiate you from many agents, because now they know exactly what they're going to have to come up with for closing costs. They know exactly what that you know exactly where they stand. Whereas before, they're all excited. I love the house. I want to make the offer. Okay, but did you know that here's your closing costs and here's the amount of money that you'll need to come up with net in order to complete your purchase? And on a listing appointment, it's a great thing to have, because you can show the seller what they can expect to put in their pocket. And if you use a program like Remine, or even the basic package in MLS through Realist, will show you if there's a mortgage on the property, and if there's a mortgage on the property, and what that amount is. And the program will calculate approximately what the seller will end up with. And it's also a great time to go over with the seller exactly what their costs are going to be, right? They're going to pay doc stamps. They're going to pay title search charges. In the FAR bar, they're going to pay for the municipal lien search, FERPTA costs, HOA estoppel fees. These are all things that a seller probably doesn't know about unless they've sold a house recently. So it's a great idea for you to come up with an upfront an estimate. It may not be to the penny, but it's going to be pretty close. So it's a great idea to have a net sheet on your listing presentation. And when you're getting ready to write the buyer's offer, it's a great idea to just show them what kind of expenses that they're going to incur. All right. So remember, in title evidence, remember, if we went back to our language up here in this paragraph where before the financing, where we talk about assignability. Okay. If you check the box on Lady 5 and your buyer wants to take title into an LLC or a trust, then you can do that up to 15 days before closing. All right. So if you check that there is no assignability, your buyer may be very limited without going back and getting permission from the seller as to how they can take title. So remember that they do have the right to change the form in which they're going to take title. All right, so if we go down to the check boxes on 185, 189, here's where typically in Collier County, it's called buyer picks, buyer pays. In Lee County, it's more seller picks, seller pays, but you have a choice here. And my experience is that if you have the buyer, even though the buyer is going to have to pay for title insurance, if they check the box on 189, the buyer then has the ability to select the title agent, closing agent, and has a little more control over the process than if the seller picks the title agent and pays for title. So I've seen a lot of buyers say, well, I don't want to spend the money. I want to spend the $2,000 or whatever for the title insurance. I'll let the seller pay that. And then the seller picks a title agent that may not be the best in the world, but's giving them the best deal. And I'm not sure that that's 100% great for your buyer. Mark, will you comment on that? What do you advise a buyer as far as picking the closing agent and paying for title?
Choose the neighbor contract, and then you don't have that issue.
There you go. Unfortunately, we have to live with both of these things.
Well, we don't have to. There's nothing that says you can't use the neighbor contract in Lee County. It's just Lee County agents are more comfortable because they're familiar with the FAR/BAR contract than they are. They may not have had much experience in Naples or Marco Island, and so they're not familiar with the neighbor contract.
So what are your thoughts if you're in a FAR/BAR and you're in Lee County? I still kind of recommend that your buyer lean toward choosing their own closing agent and paying for the owner's title policy rather than leaving it up to the seller. What are your thoughts, Mark?
Well, in today's market, I don't want to lose the deal over who's paying title insurance. If the seller says, I've got 4 offers on the table and yours is the only one where the buyer is choosing the title to pay title, and the rest of, I mean, they might look at it as a benefit, as a savings. And if, on the other hand, I've put in the escrow agent, not the closing agent.
That's right.
As a Naples attorney, and the listing agent doesn't understand the contract, doesn't know the distinction between the escrow agent and the closing agent, and says, no, the seller is going to be choosing XYZ title company for the closing. Well, that's fine. That doesn't mean the escrow agent has to be the title company.
Okay, thank you. So the Miami-Dade regional provision doesn't apply unless you're selling a property in Miami or Dade, so we can move on from there. Survey issues, remember that there's a survey period in the contract and it ends 5 days prior to closing. So if you have a lender, chances are they're going to want a survey. If the buyer, the chances are they're going to require a survey from the buyer. Whoops, I don't know what I just did, but I'm going to stop the share here and go back to here. All right, hold on a minute, technical difficulties. But if the survey issues can be significant, they really only come into play when it's a single family home or a HOA where the buyer, if the seller owns the land underneath the building. So an HOA may require a survey, right? And definitely on a single family home, they'll require a survey. So it's important that you understand that that survey has to be done 5 days prior to the closing date. Let me go back and share my screen again. I don't know what I did, but
While you're navigating, so we're finding, at least in the deals that I'm involved in, it's taking 3 weeks to get a survey. So when you have buyers who say, I'm cash and I'm ready to close in a week's time, if they're not getting a survey, that's one thing. But if they are wanting a survey, you need to write the contract to be able to allow sufficient time to get the survey.
So, and if the buyer, it says if the seller has one, they need to furnish it to the buyer. the seller can do what's called an affidavit of no change, which basically says there's been nothing done to this property, nothing, no buildings added, no fences, no change since I bought the property X years ago. Then the seller can provide that survey along with what's called an affidavit of no change, and that's the same as getting a new survey. One of the things that I've seen come up here is that there's a lot of demand for surveys. It's died down a little bit probably because people aren't refinancing at the rate they were. But I've had cases where the surveyor's trying to get as much done in one day as possible, and there's pins in the ground where the surveyor has taken their measurements from the prior survey. And for some reason, they have trouble locating the pins. So they put their own pins in, and those pins create an issue with the title. They create an issue with setbacks or one of the key elements. So I've had a case where that new survey, obtained kind of in haste, has created problems with the survey objections for not being set back far enough from the property line, so forth and so on. So it's just an issue out there. Surveys are a little tough to get. If the buyer's going to need one, the lender says you got to have a new survey, try to get on that as soon as possible. And your closing agent can possibly help you, to recommend or order it for you.
And order the elevation certificate at the same time.
Okay, those are not as critical as of April 1st, because the new FEMA flood rates went into effect, and they generally don't require an elevation certificate to give you a quote or write you a policy. However, if there's an issue in their rating system, an elevation certificate can help the buyer to save some money. So it's not quite as essential as it was prior to April 1st, but still an elevation certificate, if you have one or you can get one as part of the survey, it's only an extra, I think, $125. Not a bad idea to have one. Home warranties. I want to talk a few minutes about home warranties because if you're dealing with a home that's 5, 10, 15 years old, chances are not everything's brand new. Now, if it was newly remodeled, all the appliances are new, the air conditioning's new, the roof is new, okay. But in general, homes that are more than 10 years old may tend to have issues. So one of the things that when I was an active agent, what I used to do a lot of was I would buy the buyer a 1-year home warranty. And that would cover all their major appliances, air conditioners. It would cover electrical problems, that sort of thing. And it was generally somewhere in the neighborhood of $400 for the year. But you'd be surprised the number of times things went wrong, like the air conditioner went out 2 months after they moved in, or they discovered an electrical problem, in a certain part of the house, plumbing problems, anything to do with appliances. And the reward you get from doing that is you can't deduct more than $25 on a closing gift, but you can deduct the entire amount of the home warranty as an expense in your taxes. That's a minor advantage. The major advantage is the buyer has a problem. They call the warranty service, they pay the service call, which is usually $75 to $100, and everything else is covered. So I've seen a lot of potential inspection items and things that are not necessarily defective, but they're mentioned on the inspection report that the seller's not obligated to repair, but a home warranty might cover. So I think you need to kind of be sensitive to what the age of the house is and what potential problems there might be. But sometimes a small expense in buying a home warranty for a buyer or having the seller purchase it for the buyer can be really effective. So just my 2 cents worth. I think that mainly what the inspection finds is normal wear and tear. As soon as the home warranty is booked, you can expect that it'll have some kind of coverage. I know I've had one on my house every year since I bought it 10 years ago, and every year something breaks. And so every year I get more back in terms of coverage than I pay in. So to me, it's worth it. I like them, but not everybody does. There's pros and cons. Another thing you can do if you have the seller and the seller's not in residence, they're gone for the summer, you can generally get a policy that offers sellers coverage during the life of your listing and then transfers to a home warranty for the buyer. And I've used that again very successfully in listings. So the seller goes back home and you go to do your regular check on your listing, and it's hotter than blazes in there. You cycle the air conditioner on and off, nothing. So the seller calls the warranty company and says, I need a service call. You meet them out there. Sure enough, there's a problem with the air conditioner. So for $75 for that coverage, the home warranty company paid to repair the air conditioner. Not a bad deal. You think your seller might have been happy with you because you saved them a possible great deal of expense. So I think home warranties are important, and I think you should consider them. But the office has a couple of different preferred vendors that offer these warranties, but they're generally for the basic plan, $300 to $400. Depends a little bit on the age of the house and what you're covering. And if you're going to add pool coverage to that and everything, it runs it up there a little bit. But I don't do a lot of business, but I had a listing last year with a widow of a couple that I'd sold the place to 10 years ago, and she knew absolutely nothing about the place, nothing. Husband did everything. So I bought a home warranty, seller's coverage, and going to the buyer because we had no real knowledge on when was the last time the air conditioner was serviced, who's the pool, when was the pool pump put in, when was this, when was that. Didn't really have a lot of information, but felt like, hey, if the buyer's covered for the first year from any major problems, they're going to be happy. The seller's going to be happy if she has an issue between the listing date and the closing date. She's covered for anything that might go wrong. So that's my 2 cents worth on home warranties. I like them, and they're inexpensive relative to the amount of money they can save a buyer or seller. And generally, it's something you can provide and add some value to your customer there. Okay, so the special assessment paragraph on 205 to 219 is only for municipal liens and assessments. City of Cape Coral has a number of assessments all over for sewer. They're extending the sewer lines and the water lines to properties that weren't developed. So there's some assessments out there. There were some assessments in Bonita, areas of Bonita, to convert from septic to sewer. So there may be some municipal assessments out there. And if they are, then you want to make sure you know what they are. And many of them are installments. So a lot of times you'll check the box that said the seller shall pay all installments due prior to closing, a buyer pays afterwards. Or you can check the box seller shall pay in full. Again, the condominium and HOA assessments are dealt with the condominium and HOA rider. So this is only reference to, let's make a note, this doesn't have anything to do with the assessments from the associations, strictly public body assessments, okay? So now we're into the disclosure part of the contract, AKA boilerplate. However, there are a few traps in the FAR contract that you should be aware of. Radon, even though it's defined here as a defined term in the disclosure section, is not covered by the FAR contract. So if your buyer does an inspection and the radon comes back above 4, there is no provision in this contract for the buyer to ask the seller to fix that. Now we have some language that I can give you that actually comes out of one of the other Florida bar contract or Florida realtors contracts that basically says, hey, if the radon is over 4, and the seller doesn't choose to remediate it, either party can cancel. So you might, if your buyer's sensitive to radon, and a lot of people that do come down here are sensitive a little bit to radon. If you're, if there's any type of lung issues, smokers, that sort of thing, radon can be important. And you can ask your inspector for probably $250 to $300 to do a radon test. The home has to be sealed for 48 hours, and they take a reading every hour for 48 hours. And then that goes, excuse me, to a lab, and the lab will produce a report. And the average radon level over a period of time is taken. If it's below 4, and I'm told by the radon experts that 4 is very low and not very harmful. But I've had, in my experience, there are certain areas of Collier that are developed, like the vineyards. A lot of the vineyards fill dirt came from the quarry lake out there. And yes, it had radon in it because it was down, way down in the surface there, and there was some radioactivity to it. So yeah, radon is a problem. If your buyer wants to inspect for it, you better make sure you put the language in that will allow for your buyer to request remediation. Permits, again, permits are a very important part of life in Collier County. You have to understand the seller's basically saying, I don't know of any issues here that were not permitted or that were permitted and not closed properly. I have no knowledge, and the seller's disclosing that. However, once you go to contract, your closing agent will normally run what's called a municipal lien search. They'll check for any code enforcement violations. They'll check for any open or expired permits. They'll check for any liens that are on the property, and they'll come back with a report. And if they come back with a report that says, hey, there's 3 permits here that are, one is expired and the other 2 are still open, haven't been closed out. Those could be a very minor thing, which you can hire companies to go in and do the investigation and get them closed. Or they could be a very major thing where the contractor you hired, the seller hired, did the job but didn't bother to have it filed out. So it could be that it's there and it's working, but it's not up to code. So you have to be very careful with permits. And remember, one of the buckets in the repair process had to do with permits. Mold, again, was an item that was not previously dealt with by the 5R contract. There is a rider that has been added to the contract, rider I, which basically says, hey, I'm going to inspect for mold. If the potential remediation is over a certain dollar amount, the buyer has the right to cancel. We've been through several iterations in the NABOR contract, and we basically, in this new process, this new rider, then all forms of mold are on the table. So in the NABOR contract, we went to great length when we revised it a few years ago to talk to mold experts and mold remediation people. And we found that there are a number of forms of mold that are everywhere in Florida that are typically non-toxic and non-allergenic. Aspergillus and penicillium are the 2 most common forms of mold in our world, and there are very few, if any, strains that can be considered toxic or allergenic or harmful to health. So we excluded those forms of mold from the contract. In the FARBAR, just basically, it's the first time they've ever dealt with mold in their contract, and as a result, any form of mold can generate a remedial action, which if it goes over a certain amount, the buyer can cancel. So Mark, very accurately mentioned flood zones and flood zone elevations. This does have there's a rider, or there's a section here on line 243 that if the buyer has a great deal of difficulty getting any type of flood coverage at a reasonable rate, that they do have the right to terminate. And it's also dealt with in a separate rider. Okay, the energy brochure is available in your contract library. The buyers acknowledge receiving it. Not a bad idea in your packet to your buyer that you put that in there and just have them initial it. It just basically talks about energy efficient appliances, and it is acknowledged in both the neighbor and FARBAR contract as the buyer has received it. If your home was built prior to 1978, you must have a lead-based paint disclosure. There's a little lead-based paint information booklet that's in the library that you can give to your buyer. Not aware of a huge amount of lead-based paint issues. We had, like a lot of the popcorn ceilings in the older homes had asbestos in them, but not aware of a lot of lead-based paint, but it's a federal law. And one of the things you need to remember, make a note of it, that the listing licensee and the selling licensee must also sign this form in addition to the buyer and the seller. And I'm told if they audit your lead-based paint addendum and it's lacking or not completed properly, that you can pay up to a $12,000 fine. So, you know, I still do all the compliance, and if I see a lead-based paint addendum submitted that doesn't have all the signatures on it, then you get a little love note from me and Kelly saying, hey, get this signed and let's make sure we comply with the law. So basically, this is a warning that says, hey, if you are moving into a condo or HOA, you need to read the rules and regs and the and any issues with the HOA or the condo association. Make sure you look at that. They're suggesting you do it before you go to contract. In the condo side, remember, you got a 3-day right of rescission if you're looking at the condo docs and you find something that you don't like. Now, you know, Mark will tell you that some listing agents are requiring that the buyer review and sign the condo disclosure, the condo receipt of documents, and waive their rights to the 3-day, and therefore waive their rights to the 3-day walkaway, because they don't want the buyer to go under contract when there's multiple offers, and all of a sudden, you know, 7 or 10 days out, the buyer comes along and cancels based on their 3-day right of review with the.
Jeff, let me just clarify one thing. We didn't ask them to waive it. We just asked them to sign that they received them before we accepted the offer, so that the clock started ticking from that 3 days. So they could still terminate within the 3-day period. It's just we didn't want them to say, well, I never got the condo docs until a week later, and now I'm going to cancel.
Yeah, and remember that the condo docs include all 7, one of which is that kind of innocuous state of Florida 3-page PDF that talks about the risks of condo ownership. So the buyer has to get all of those and then has 3 days. So I've seen
as the listing agent, I feel it's my responsibility to get all that at the very beginning from the property manager. And oftentimes, if you're lucky, I guess I should say, you might find it on a community website, in which case you could direct people to that. So you're not actually sort of handling the documents. That's always a risky thing, is did you get every updated version of the documents? So if you're getting from the property manager, that's great. If you're finding it on their website, that's great, but don't rely on what the seller is holding in their files.
So, yeah, and I've also seen if you talk about making your offer look a little better, I have 2 comments. As a listing, I always upload those documents and put it on my listing. So the buyer's agent, all I have to do is download it and give it to the buyer. And can I mute all from me? I don't know. Where that came up. Anyhow, I think that if you're a listing, go ahead and do those documents and upload them with the listing so that you can be out ahead of the game. And actually now I've seen buyer's agents say, okay, we're going to submit our offer with the receipt of condo docs already signed, and say, okay, we've already reviewed the docs. We're not going to use our 3-day period. We've already done that before we submitted our offer. They're again making the offer stronger in the eyes of the listing agent. So
what I'm also seeing, Jeff, is the listing agents aren't always doing their due diligence. And so therefore their budget was from 2021, or the frequently asked questions was from 2021.
Yep.
So trying to get the current documents from the property manager or from their website becomes more important.
Yep. And remember, it's a get out of jail free card for the buyer until they've had had all those documents for 3 business days. And again, we'll see it in the rider, but it's 3 business days after receipt. The date of receipt is not considered a day, so it's actually a 4-day period. And if you do it right for your buyer, you get the documents to them on Friday. That's day 0. Saturday and Sunday don't count, so they have till Wednesday to review them all. That's a little extra bonus time for your buyer. But it's very clear that this is one of the most difficult parts of contracts, because agents don't always understand what they have to provide. And so as a buyer's agent, I was always like, go ahead, I'm going to be assertive on this. I'm going to call the property manager. Sometimes the title company, our title company, will provide you with the articles of incorporation and the rules and regs, or not the rules and regs, but the bylaws. And then you can get the current copy of the rules and regs and everything by calling the property management office. They'll have the application for ownership, for membership. They'll have the current rules and regs. They'll have the Q&A, and they'll have the current financial statements, all of which are required. And if you know in advance that your buyer's really wanting to buy in this community, you can go ahead and call and get those. And as Mark said, sometimes from a website, but in all cases, you can get them by calling the property management. And infuriatingly enough, some of these people want you to pay for the documents, which oftentimes the association doesn't even know that the property manager is making profit. But I've paid sometimes up to $100 for those documents to get them when the seller didn't have them.
Some of the recorded documents you're able to, I'm not sure about Lee County, but at least in Collier County, you can get on the clerk of court's website, but you have to know what you're doing and how to search for them. So they may not, you might think, oh, I've got them all, and you're missing one amendment, and now you're in trouble because you didn't provide a complete set.
Yeah, I mean, I'm happy to help anybody with it. I've certainly done enough of those searches, but what'll usually happen, and where it gets sticky, is the developer will develop it in 9 different units, developmental units, and each one will have its own name. And then at some point in time, they'll consolidate all those 9 into one, and it will have a different name. So you have to be careful that all the articles and everything will be what's called amended and restated, so that they take all the amendments, combine them, and put out a new set of docs. If they don't do that, then you really have to get the original ones and add every amendment, and it can be a little tedious. So don't discount this part of the contract, because it's very important that you get those documents, and you can certainly put yourself in a situation with a buyer or seller where they don't have the docs, and it could create some havoc in the contract. FERPTA, wow, we could spend a whole hour on FERPTA. Basically, the FERPA is an IRS a tax act that says we passed this because many of our foreign sellers were cashing the check at the closing and then headed back to their native country and without paying their US income taxes on the sale. So now, if the seller is a foreign person, then they have to deal with some withholding requirements based upon the amount of the property and whether or not the buyer signs a waiver of occupancy. So without going into a lot of detail, if you're in the MLS and it'll say FERPA yes or no, if it says FERPA yes, that means the seller is responsible for, for withholding some money at closing. But it's the buyer's agent, the buyer as the agent, who collects that money, usually through the title company. And then if it, for some reason, is insufficient or doesn't get collected properly, it's still the buyer's responsibility for making sure that the seller's taxes were withheld. So you have some buyer liability in this, and it's really not a bad idea that if there's a foreign person involved in the sale of the house or residence, that you get some input from your friendly local real estate attorney as to how best to handle that. Because the buyer can be on the hook for quite a bit of money if it isn't withheld properly. And when the tax bill comes in, if there's not enough withheld, it can be a problem for the buyer, not necessarily even for the seller. Okay, so seller's disclosures, obviously everybody knows what a seller's disclosure is, but one of the things that I find a lot of is it's not required in the state of Florida. Seller's disclosures are not required in the state of Florida. So if your seller has never lived in the property, if it's an inheritance, it's difficult for the seller to fill out a seller's disclosure, and oftentimes they can incriminate themselves by putting information in there that they don't fully understand about the property. So if there's reluctance from the seller to fill out a seller's disclosure, then the seller is not required. However, from a buyer standpoint, you'd always like to look at the seller's disclosure and see if there's anything in there in their report that would give you any kind of pause. Like, we had a leak after Irma, we had it repaired, everything's cool. Well, you might want to dig into that a little bit more, have your inspector dig into it a little bit more to make sure they didn't take the money from the insurance company and throw a Band-Aid on the problem and it's still there when you inspect. So be a little careful with that aspect of it, but the seller does not have to fill this disclosure out, and you will have agents that will claim up and down that it's a requirement, but it is not. So, and there may be reasons when you're working with a seller who says, I don't know much about the property, I've never lived there, it was my mother's home, then just don't fill one out, rather than try to fill it out and put things in there that may or may not, or could incriminate you. It's to the seller's benefit to provide a seller's disclosure in the aspect that if they disclose, for example, that the ice maker has never worked, we never use it, we don't believe in that kind of ice, and then the inspection shows that the ice maker is not working, by declaring that and having accepted by the buyer, the seller is waiving their liability and waiving their chance to ask the seller to repair it. So, okay, so the paragraph 11 is, to me, one of the most important aspects of the contract. It's true of an as-is contract, it's true of a regular contract, it's true in FAR-BAR, and it's true in NABAR, okay? Except for ordinary wear and tear and casualty loss, and those repairs that are required by the contract, sellers shall, legal term, shall maintain the property, including but not limited to lawn, shrubbery, and pool in the condition as in the effective date. Okay, when we back up to paragraph 9, the buyer is entitled to escrow up to 125% of the estimated cost of these repairs for the seller not having for the seller not having maintained the property. So if the seller can't shut the sprinklers off and say, yeah, I don't need to water this anymore, and you come and the lawn's brown, the shrubbery's all dead, that's the seller's maintenance obligation. The seller has to give you some money to put all that landscaping back. A lot of times you'll see it where the air conditioner probably was set maybe to 85 or something when they left for the summer, and you develop moisture inside some of these cabinets and everything, and possibly the early signs of mold. So there's a big reason why you should inspect a property and have a baseline that when you go to the walkthrough inspection with the representative of the buyer or the buyer, that you have a baseline to say, hey, the air conditioner was cooling properly when we went to contract and when we inspected it. And now it's warm in here. There's something, there could be some problem. Well, now the seller is required to address that. So we don't recommend under any circumstances that the buyer waive inspections to make their contract look better, because the seller's maintenance obligation is almost impossible to prove if you haven't been in the property since you wrote the contract. So be sure when somebody says, oh, I don't care, it's a new place, I'm going to waive inspection, I couldn't care less, then you get them to sign the buyer's notice that says, okay, we don't recommend that. You realize you can't even go in the property from the time you write the contract to the time you go to the walkthrough. But if you want to do that, sign this little waiver that keeps Jeff Jones out of big trouble and the brokerage and you. Because once a property closes and a buyer discovers a major defect, and it will almost always be your fault. Why didn't you tell me to inspect it? Well, you told me you didn't want to inspect it. No, you should have told me. You know, anyhow, I'm just waiting for the shoe to drop and for somebody to file a big lawsuit against us because they waived inspections and found a problem afterwards. This could be permit issues. It could be a lot of different issues.
Jeff, when you say file a lawsuit against us, that's both the market center and the individual agent usually, is that correct?
That's correct. And, you know, I don't know, we were unclear as to whether our E&O would cover that if the buyer didn't sign the waiver. So there have been apparently a small number of court cases where the buyer has sued the seller and said, you should have told me about this, you should have known it. And now I've got a big problem, and therefore, you know, you pay. And so far, courts have ruled, hey, you waived inspections, you waived your due diligence, you don't have any right to ask for those monies. But that may not stop a lawsuit from happening against you and against the company.
You still have to pay for attorney's fees to defend yourself.
Yeah, I mean, that's not necessarily cut and dried, but typically your independent contractor agreement says that if the market center has to incur legal expenses to defend your case, we can ask you to pay for those legal expenses. So I've seen it where there was such an egregious situation that the market center would pay for it, and because they had a high anticipation of getting their money back. But you know, theoretically, if you're involved in a lawsuit where we're looking for E&O coverage and it's not there yet, you could have to foot the bill for some legal expenses. So be aware of that.
And Jeff, can you also address the 125% as to how that's determined?
Yes, in the seller's maintenance obligation, or for an inspection item that's not done prior to closing, there is a paragraph in here that basically talks about how that works. And right here. Prior to closing, seller is unable to meet the maintenance requirements required by paragraph 11 or the repairs required by paragraph 12. The sums equal to 125% of estimated costs to complete the applicable items, but not in excess of the general repair limits, shall be escrowed at closing.
So how does one determine on the day of closing what the cost is going to, estimated costs are, if you don't have a qualified contractor to give you that estimate?
Yeah, sometimes, what I always recommend is if there were repairs or if the home is older, that you bring your inspector with you to the walkthrough. And if you discover an item, chances are you can at least get on the phone with a licensed professional and try to get an estimate. Then you can use that estimate as the basis for your 125.
And if there's a difference between what the seller thinks the 125% or what the estimate is and the buyer, how is that resolved?
Well, in this particular case, the way I've been instructed is there's not a lot of discussion where the seller can say, wait a minute, that's way too much. Because the seller either should have completed the repairs or should have maintained the property in the condition it was in at closing. So in the cases where I've seen it happen, it's the buyer produces an estimate from a licensed professional and 125 gets unless the buyer says, I don't need you to escrow 125, I'll take 100. But it's not, I don't think, a bilateral situation like it is in the inspection paragraph, where if the buyer and seller don't agree on the cost of repair, you get a third estimate in there. But it's my understanding, Mark, from teaching this with a couple of pretty good attorneys, that this is a kind of a one-way buyer is in control situation, because it's basically the seller hasn't lived up to their obligations.
Okay.
All right, so we'll talk.
By the way, if I'm not sure if this is true with other inspection companies, I've used Max Home Inspections, and they put an estimated range in their inspection report of what they, what I guess the industry standard for replacing a GFI outlet or something of that nature, and it gives a range of money. So you could probably point to that for your buyer and use it as a justification for how much is a reasonable amount to estimate for those repairs that need to be completed.
Yeah, this is a preferred vendor of ours, Max, but they do also provide a little bit of coverage for repairs that the buyer has to make that weren't anticipated or caught at the walkthrough. So there's a little bit of coverage in that respect. Okay, so let's talk about the inspection part of it. This again is the functioning of it is much different than NABOR. So the buyer has their inspection period, and during that inspection period now, the buyer must make requests for general inspection repairs, property condition repairs, general inspection, WDO and permits. All right. So in the NABOR contract, the buyer has X days to inspect, and then up to 5 days after the inspection period to ask the seller for repairs. In the FARBAR contract, if you have a 10-day inspection period, by day 10, you need to request the seller, here's my repair request, here's my copy of my inspection report, and that has to be done by the end of the inspection period. Very different than NABOR, which gives the buyer a little 5-day window after inspection to make their repairs. So this is, if you got 10 days to inspect, you better have the report back in day 7. So if you have to do some checking around, and you need to have it to the seller by day 10. Again, remember, these dates are all calendar dates. If the deadline inspection period ends on a weekend or federal holiday, the date is moved to the next business day at midnight. But make sure not to dally on this, because I've seen people get into trouble saying, oh, I got 5 days. No, you don't have 5 days. It's the end of the inspection period. If you don't make requests, you're deemed to have accepted the property the condition it was in, which probably is not what your buyer is looking for. So let's talk about general repairs. This is kind of similar to the NABOR contract in that it's systems and equipment that aren't working. And it's a defined term And then you have the ability, once these tests are made after the inspection, to request the seller to make repairs. And in FAR bar, they have to be done by a licensed contractor and receipts have to be provided. In NABOR, we require to have the licensed contractor requirement, but not the requirement to provide receipts. A little bit of difference there. But remember to really camp on to these conditions here, where it says seller is not required to repair or replace cosmetic conditions. And again, remember what cosmetic conditions are. Pitted spots in the pool, normal wear and tear is what they're: cracked roof tiles, curling or worn roof tiles, limited roof life, was not a defect as long as there's no evidence of any leaking or structural damage. So understand what the conditions are for your buyer to ask for a credit. And remember, these are general property repairs. So the buyer can ask the seller on or before the end of the inspection period to make repairs up to the general repair limit. The seller then has 10 days after receipt of that and to reply to have the repairs estimated by an appropriate licensed person for the copy delivered repairs to the buyer. Buyers and sellers, here's where Mark was talking on 314. If buyer and seller's inspection reports differ and the parties cannot resolve the differences, buyer and seller together shall choose and equally split the cost of a third professional inspector. Okay, that gets pretty tedious. I'm not sure that I've seen it done very often, but generally, because we're asking for licensed contractors to provide estimates, that the estimates are generally workable as so long as they fall into the repair limit. All right. So there's a section here that gets misunderstood, and basically remember that if the cost of repair exceeds the repair limit, the seller may elect to pay the excess by, the seller can do them and say, okay, I don't care what the limit is, I'll do them because they need to be done. Or he can ask the buyer, what ones do you want that add up to your $5,000? There's $8,000 here. What do you want that's, up to $5,000? All right. So that's a little bit of back and forth in there. Now, the last sentence, 323 and 324 and 25, it says if neither party delivers such written notice to the other, then either party may terminate the contract and the buyer shall be refunded the deposit. Okay, so people read that and say, okay, if I request the seller make repairs and the seller doesn't want to do it, or the seller says I'm only going to do it up to the repair amount, then I can cancel. There's nothing in that sentence that allows the buyer to cancel unless there's been no written notice between the buyer or the seller. So if you made your request inside the end of the inspection period, the seller has 10 days to come back to you and say, here's what I'm going to do. And that and it only applies if neither party responds to each other. If you send the seller a repair list and the seller doesn't respond, okay, that's a case where neither party delivers such written notice to the other. All right, then if the seller didn't respond, now you got a case for it. But if the seller responds and says, I'll do this, this, and this up to your limit, there's no cancellation for the buyer. I've seen that sentence there pretty well. Oh, the buyer has the right to cancel. No, the buyer doesn't have the right to cancel unless the seller doesn't respond. Same little ditto here for wood destroying organisms. If there's termites, then the buyer can ask the seller to make repairs. There's a, I don't know, maybe it's just, there seems to be an issue with where the inspector says, the termites in here are all dead, but there's some droppings. Well, what does that mean? It means in the inspector's eyes, who's not a WTO expert, that there's no active termite infestations anywhere in the property. But the fact that there might have been some there, maybe you can't see any damage that was done. Maybe the inspector can't see any damage that was done. So make sure you protect your buyer. If the inspector's report, that's why I always recommend you get at least 10 days for inspection. I see these things coming through 7, 5. Yeah, you get one bite out of the apple there. You can get one inspection done. But what happens if the WDO report comes back inconclusive and you're at the end of your due diligence period? You're stuck. You can ask for the repair based on the fact that there was past damage, but under this, the seller can say, hey, there's no evidence of active termites. So I'm not doing anything. So be careful with that. Permits are probably the wild, wild west of this contract, because it's the seller is disclosing the fact that they know of no permit issues or lien issues, but that doesn't mean the seller doesn't have a problem and they just haven't been informed. You know, I hired Benson Air Conditioning to go out and fix my air conditioner, and they told me that we needed a new one 5 years ago, and I paid them the money, but they never closed the permit out. So now I've got an open permit or an expired permit that hasn't been closed out. And it's up to the seller in this particular case. If you provided a repair bucket in there, it's up to the seller to do this up to the amount that's in that repair bucket. Now, this is if cost to close open expired building permits or to remedy a permit violation exceeds the permit limit. So I know everybody just likes to let that default to 1.5%, but even if it's a $500,000 property, that's $7,500, and that may not be enough to close an open permit. So if you want to write a regular contract in Firebar, make sure you put some money in there, especially if it's an older home and it's been remodeled, air conditioner's been replaced, roof's been replaced. You don't know what the permit situation is, but it could cost a lot more money than just 1.5% to address these issues. Okay. Sorry, nothing in the chat. Okay. Walkthrough inspections. Broker Jeff believes that walkthrough inspections are one of the most important periods of time for the buyer in the entire contract. So you want to make sure that you have lined up, I think, your inspector. I had when I taught the Firebar, a couple of agents chimed in, because I've never advised you as the agent to be the buyer's representative, and I've never thought that the E&O would cover that. But I had a couple of agents say that their brokerage firm has a release that the buyer signs if they do the walkthrough for the buyer, not to hold the agent or the brokerage responsible. However, I'm still not sure that would help your E&O coverage. They're pretty stringent on the fact that if you're the representative, you take on the responsibility of making sure that everything's there, that the repairs are all done, and all the inventory that was agreed upon is there, and that everything's been repaired properly. And you become the center of that process. And if you miss something, I still think you could be held accountable, regardless of the buyer signing off and saying, I asked you to do it and I'll hold you harmless. So be careful with that. What can you do? You can always ask the inspector to come back. And again, we talk about calendaring events in these contracts. That's a major event. So if you want the inspector to come back and your closing is next week, you might want to call that inspector a week or 10 days before and say, hey, I'd like you to come back and do the walkthrough with us, make sure all the repairs are done right, and make sure that you were the one that did the baseline for us. Is everything the same as it was when we did our initial inspection? Usually $100 to $150 is all that it costs, and it's money well spent. There's lots of stories out there. I had one back when I was an agent where there was a little moisture in the hall closet it was a second floor condo. There was a little moisture along the baseboard there. And we noted it on the inspection, and the seller had a repair, a handyman go in and recaulk all that and clean it all up. We brought our inspector along. The inspector tested it again, and it tested moist. So lo and behold, we went around behind that closet, and there was a shower. So the shower pan was actually leaking, and what they did was they put a little bit of caulk in and cleaned up that molding and said that's good. It turned out that she ran the shower for 10 or 15 minutes. That area got very wet again. So we knew we had a leaking shower pan. We're on the second floor. You know what that means, that eventually that's going down south to the neighbor down below. So we got a plumber in there and a tile expert, because the shower pan requires a plumber to put the new pan in and hook it up and make sure that it's, that the whole drain mechanism is sound. You can't do that with a tile man, but we actually got an estimate of $5,000, and we proceeded to say, okay, we're going to escrow 10, and the seller said, here's 5, I'm done. But had we not brought the inspector, and the inspector not checked an area of concern that seemed very minor, we could have cost the seller a lot of money. So are you, the realtor, capable of making those decisions? I don't think so. So I think very definitely, and if the inspector comes there and you're there, you can be there, but you're not responsible for the decisions. If there's inventory to be verified, possibly a neighbor or a friend or somebody can come and go over those checklists and make sure they're right, so you're not the source. I did ask the lawyer that I was presenting with if you could do it with a with an iPhone, do a video walkthrough or something like that. I don't know, we weren't sure whether or not a FaceTime would be sufficient for a walkthrough. All right, the FAR has a great segment 380 to 385, basically saying that if there's that all repairs and replacements shall be completed in a good and workmanlike manner by an appropriately licensed person, and shall consist of materials and items of quality, value, capacity, or better than existing as of the effective date, except as provided in 12C. Seller will at closing assign all repair, treatment, and maintenance. So a lot of the sellers have warranties when they put in a new air conditioner or a new appliance, and the contract is basically saying that we want you to assign all those warranties to the buyer, and that's a good part of the contract that we don't have in NABOR. The escrow agent, Mark touched on that earlier. The escrow agent is not necessarily the closing agent, but an escrow agent must be named as part of the contract. You can't put TBD in or leave it blank. That was up in the front where we collected the money. And here's why. Back in the heyday of 2004 and 5 and 6, when the market was going crazy and there was a lot of speculative lending, there was also a lot of speculative escrow agents, where I would name my friend Mark the escrow agent, and Mark would wink at me and go, oh yeah, Jeff, I'll be your escrow agent. And no money would ever change hands. The deal would fall apart and there was no escrow money escrowed. And so there was a lot of fraud that went on and mischievous escrow agents. So the state of Florida in 2007 said, you have to be a legitimate escrow agent with an escrow account. You have to be named in the contract. Your contract information has to be there, and the money has to go to that agent. Now, lately we've seen some national title companies come in and go, oh, no problem, we'll do this from Philadelphia. Well, Florida law requires that all deposits be held in a Florida bank. So some of their claims that they can do everything that they can locally, but they don't have an office here, not true. So be careful of that. So this basically deals with with conflicting demands on escrow when a contract falls apart. And this is a process called an interpleader. And basically the closing agent goes to the courts and says, okay, I've got $5,000 in escrow, and neither the buyer or the buyer and the seller won't sign off on it. So I'm taking this to the courts. And by the way, I get my closing, since the deal never closed, I get my closing costs and any expenses I had of maintaining the escrow. And then you, Mr. or Mrs. Judge or whatever, is going to make a determination of who's going to get the money. Well, this just in, by the time it gets to that point, it's a fraction of the original deposit. There have been fees taken out, court costs, and fees to the closing agent. So that $5,000 deposit could be $1,500. So be careful that if we don't properly resolve escrows, then they go through the escrow dispute process, and it can get a little bit messy. Escrow disputes are separate from the contract. So if your contract is terminated and now you're fighting over the $10,000 deposit, the property can go back on the market and be sold. The escrow dispute is a separate matter. Right? Paragraph 14 is a buyer, a broker get out of jail free card. That sounds funny, but basically this is basically saying that the buyer is reliant on professional inspectors, governmental agencies. The buyer is responsible for verifying square footage and facts that in the broker, they're out of the control of the broker. If I have a floor plan from the seller and I put it out there as 2,586 square feet, and it turns out it's 2,286 square feet, that's the buyer is agreeing that they will independently verify that and indemnify the broker and his agent. That's what that paragraph does. All right, so we're down to defaulto. Default works a little differently in this contract, but default resolution is quite a bit different. So remember, if the buyer defaults, the seller may enforce the rights in the contract. The portion of the deposit, if any, paid to the listing broker can go back and be used to pay the commissions. But the most important thing is the seller may elect to recover all deposits, right, as liquidated damages. So if there's an initial deposit of $5,000 and a second deposit of $50,000, and the buyer defaults, the buyer's still on the hook for $55,000. They can't say, well, I never made the $50,000 deposit, therefore you're not entitled to it. That's not true in FAR-BAR. In NABOR, that's the case, but in FAR-BAR, it's not. Seller default involves the seller refusing to close. And we've had it happen a few times here lately. And the 2 or 3 cases that I've seen go to court, the seller always loses. We had a lady that decided she didn't want to sell. She changed the locks and disappeared on the closing date. So finally, about 3 or 4 weeks later, she was in court, and the judge says, this isn't your house anymore. Hand the keys over to the buyer, pay the buyer's closing costs, pay the buyer's legal costs, and it didn't hold up. So generally, when a seller says, I don't care what you do to me, I'm not going to close, chances are they're going to end up in a specific performance situation. And there is a paragraph 16 in this contract, which basically says that buyer and seller will have 10 days and they use mandatory mediation and arbitration to settle the matter. In NABOR, we do not have specific mandatory mediation and arbitration. And this is attorney's fees on 457, which basically says, hey, whoever wins the court case will have their expenses paid by the winning property person will have their expenses paid by the losing And I'm told by the attorneys, it's not usually all of the expenses, but it's 70 to 80% of them. That's up to the judge to determine. Okay, so the real estate transaction standards are very much, we've gone over a lot of these things. This is talking about title easements, limitations that have come in the survey, talking about title exceptions that prevent marketable title from being issued. And there is a very defined period in here where a survey issue, it can become a title defect, and that the seller has time to cure that and without going into default. And the seller has 30 days after receipt of the buyer's notice to cure it. And you can extend the cure period up to 120 days. Generally, these things don't go that far. It's generally something fairly minor that can be resolved in a few days, but the seller does have the right to extend if there's a title defect that's discovered in the title process. So leases, again, we talked a little bit about those earlier. There's a checkbox up there which says, hey, if there's leases, the buyer has the right to look at them, and if they don't like them, they can cancel. Ingress and egress, obviously you have to be able to get there. And if there was an agreement by the neighbors that this common road access that accesses 3 or 4 places off of the main road, but that's common property, that can be on a survey, can be denied. It can be that the road is the property of one of those owners and not all of them, and there's no agreement to provide access and ingress. So it doesn't happen very often, can happen on some of the weird lots in the estates. We talked about time of the essence. Time of the essence means every date in this contract is time of the essence. And if it's not met, it's 12:01, the buyer hasn't made their deposit, they're in default. All of their deposits are now at risk in settlement with the seller. So make sure you understand in the NABOR contract, the only time of the essence date is the closing date. All the other dates have some flexibility in them. And the seller can declare a particular date to be time of the essence after, if it's not adhered to, but it's not automatically time of the essence. But in this contract, every date is time of the essence. Okay, let's talk a little bit about force majeure. It's defined as hurricanes, floods, extreme weather, earthquakes, fires, or other acts of God, unusual transportation delays, wars, insurrection, civil unrest, and now they've added in epidemics and pandemics. So in this contract, there is, if a force majeure event occurs, there's a requirement that if we can't close, that the time periods be extended until we can close, right? Until there's electric service and there's not flooding in the area. But if that period goes on for more than 30 days, then either party can terminate the contract. So in the NABOR contract, I think when we went through that, we talked about risk of loss, and we talked about the ability for the buyer to go back in and make a second inspection, but we did not talk about force majeure, where a catastrophe happens. You're sitting in Cleveland, Ohio, looking at Hurricane Irma go through Naples, and you're looking for a way, like, this is terrible, I need out, this is force majeure. So we don't have that in the NABOR contract. We specifically left that out, but it's very much a part of the FAR bar contract that any event meeting those definitions that goes on for more than 30 days does allow the buyer to terminate. Again, most of what we had from Irma was a foliage event. It wasn't hugely, there were some roofs involved, but it wasn't a hugely structurally structural incident where buildings were collapsed or badly damaged as a result. So there wasn't a lot of contracts being canceled by force majeure during Irma, but it's there. All right. this is just another form of conveyance. So you got to have marketable title, and you have to personal property at request of buyer be transferred by absolute bill of sale with warranty of title, subject only to the matters that provided in this contract. So basically, that's just saying that the seller warrants that they own all this stuff and they can legitimately transfer it to the buyer. So here's one that comes up infrequently. All right. Closing location. Closing will be conducted by the attorney or other closing date designated by the party paying the owner's title policy and will take place in the county where the real property is located or at such other location agreed to by the parties. Both contracts, neighbor and FARBAR, require that the closing occur in the county to where the property is located. So we have people that say, I want to use my title agent from Miami or West Palm. If they don't have an office here and all parties don't agree, you can't use, and definitely an out-of-state title company, a national title company that has no presence here. Theoretically, whoever's not paying for the title insurance policy can say, hey, I want it done in this county. I want to be there to make my signature, to do all the signing. I don't want to worry about a lot of mail-aways, and I don't want to have to chase somebody in Ohio if there's a problem with the closing. So. That FinCEN go-to reporting is not in our we're not in a targeted area. There's a lot of issues with illegal money over on the East Coast. So if there's a large large cash transaction, they have to prove the legitimate source of the funds. There's talk about bringing it over to Naples, but we haven't had any move by the IRS to do that. Closing documents, these are just the things that the seller shall provide. And here in line 560 is where they say seller shall provide buyer with paid receipts for all work done on the property pursuant to this contract. Buyer shall furnish and pay for as applicable the survey, flood elevation certificate, and documents required by the buyer's lender. So that little paragraph in there, it differentiates FARBAR from neighbor in that you don't really have the right to ask for receipts in the neighbor contract. It's not a bad idea if you're the seller to provide them, because if there's something wrong, they're either coming back to the seller, but what about the contractor that they paid and signed off as a licensed contractor? Here's my receipt. Now there's a problem. Now can I take that receipt and go back to whoever was paid for those repairs? The answer is probably yes. So obviously we know that everything is prorated to the closing date. Closing date is the buyer's, is the buyer's date. So all property taxes, HOA fees, everything up to the day of closing is a responsibility of the seller. So the seller will give credit to the buyer, or excuse me, the seller will credit the buyer for the taxes owed to the day before closing. And then that's a credit. And one of the interesting things is you might want to just caution your buyer that they're getting that credit on their closing statement. The seller's not actually paying part of their taxes. The seller's giving them a credit. So when that full tax bill comes to the buyer in November, and the buyer goes, wait a minute, the seller didn't pay their portion. Yes, they did. It was on your closing statement. So don't expect that the seller's going to pay part of those taxes. So if you have an $8,000 tax bill and you get a $4,000 credit, it's June from the seller, and you're still going to have that $8,000 bill due in November. So make sure that the buyer understands that. That's one of the things, one of those scorching phone calls you'll get in November. What do you mean? No, wait a minute, hold it. Look at your closing statement. That tells you that you got the money from the seller at closing. All right. Seller shall, upon reasonable notice, provide utilities and access to property for appraisals and inspections, including a walkthrough or follow-up walkthrough in the event of a force majeure event prior to closing. So the seller has to be reasonably responsive have the water and the power turned on and make it accessible to the, and it includes appraisals. Now, where this got sticky was, let's say the buyer checks cash and they still want to get an appraisal. Then the seller can't say, no, you check cash, we're not letting your appraiser in. That's not true. And if there's an appraisal contingency, then that is even more of a reason why a buyer with cash may want to get it. So this has to do with fire and casualty. And basically the interesting thing is FAR with the cost of trees and foliage says shall include the cost of pruning or removing. In the risk of loss in NABOR, we actually require the seller to replace trees and damaged foliage up to 1% of the purchase price. In this particular case, it's only requiring pruning or removing the damaged trees. Pretty big difference in the case of Irma because we lost a lot of trees and shrubs. So if the cost of restoration exceeds 1.5% of the purchase price, buyer can take the property as is with the 1.5% or receive a refund or deposit and release. So this is another area of get out where the seller has to pay all costs, but not in excess of 1% of the 1.5% of the purchase price. If it exceeds that, then the buyer can cancel. 1031 exchanges. This basically is an agreement for all parties to cooperate. Delivery is an interesting thing. So you can't record the notice in public records. That's a violation of the law. You can't record that contract. Obviously, the property appraiser is going to record the sale, but you cannot record a copy, a facsimile or electronic copy of the contract. All right. All notices must be in writing and may only be made by mail, facsimile, personal delivery, or email. You see where that includes text anywhere? No. Text messaging is not a form of delivery. Couple of other things. The day of delivery to the agent of condo docs and HOA docs is considered part of the overall process. So if I deliver my condo docs to Mark on Friday, that's day 0 for both Mark and the buyer. If Mark doesn't get them to the buyer till Monday, then the buyer's review period is cut short. In the NABOR contract, delivery to the agent does not constitute delivery to the buyer. So be aware in these condo docs and everything that if you get them and they're delivered to you and you take a day to deliver them to the buyer only has 2 days to do their review. Obviously, let's see. No modification or change to this contract shall be valid or binding upon buyer or seller unless in writing and executed by all parties. You can't agree verbally that you're going to take care of something if it's not in writing. So you need to write an addendum. There's no amendments in the FAR contract. You need to write an addendum and have everybody sign it if there's going to be an additional credit or the purchase price is going to be reduced by some repair requirements. That's certainly something that has to always be in writing. Let's see. Collected funds is defined there. This again is FERPTA. We talked a little bit about it. We can spend, a whole period of time on that. So we really only have a couple things here. The riders, which we can go over we'll go over in the next few minutes of the next contract class, so you know what all the riders are and what they do. But the riders have to be checked if they're going to be part of this contract, okay? And there are a number of them. We'll go over all of them. Some of them, the condo rider, the HOA rider, are very important and must be integral parts of the contract and must be checked here, okay, in order to be included. Additional terms. Okay, so we'll also talk a little bit about the as-is contract next week. Very similar with the inspection period changed, but I do have a few things that I could share with you in a FAR as-is contract. You want language in there that requires the seller to close all open expired permits and deal with any municipal liens or code violations. Because if you don't put that in there in an as-is contract, the buyer is not covered by permit issues. There is a counteroffer form in the FAR language that you can use. We don't have one for NABOR, but there is a counteroffer form. We can take a look at that. Again, it's very important. The attorney in our last class, this buyer's address for purpose of notice and seller's address. If there's a problem and the seller needs to notify the buyer or vice versa, and there's nothing in those areas, how do you get notice to the other side? Hopefully it goes through the agent, from the agent to the seller, or from the agent to the buyer. But anything in writing that's required to be notified, to notify the other buyer or seller is not there. It has to have an address. It could be a home address in Connecticut. It could be somewhere where we can get notice to the other party. And last but not least, we added this language in both contracts. You can't use the sales contract to adjust compensation, because the sales contract is between the buyer and the seller. The listing contract is between the broker and the seller. That deals with compensation. So if compensation is going to be changed, if the listing agent or the selling agent is going to make a concession, or we're going to modify the compensation that's in the MLS, which is the guarantee of compensation, you can't do it in this contract. So I see the when you go down below here, I see the cooperating sales associate put 3% next to his name, or 2.5%. That means nothing. And whatever's in the MLS for the buyer's agent, and whatever's in the listing contract for the listing agent is what the compensation is, unless it's modified in writing by the brokers. Don't put seller's agent to contribute 3% or 1% of their commission toward closing costs, because it's not enforceable. If the other broker hasn't approved it, you can write whatever you want in this sales contract and it won't be binding at closing. So be careful with that. And it's 3:00. So we got through the entire FAR contract, and we'll do the riders and the as is next week, and then we'll move on to other pastures. But we do a lot of FAR contracts. A lot of our agents do business from Cape Coral to Lehigh Acres, all throughout Fort Myers, and this is the predominant contract.
Thank you, Jeff.
And it's good for you to know. Hopefully you've made some notes on the differences between time of the essence, between all deposits being at risk at day one, and some of the other nuances in there about repair buckets and things like that. Again, this contract is very important that you calendar your dates and put them in a calendar, put them in your phone, whatever you like, but they need to be, the date is default. So I want to know a couple days before that, so I can be in communication, whether it's a loan approval date, whether it's a deposit date, an inspection date. Remember, in the inspections, you have to notify the seller by the end of the inspection period. You don't have 5 days like you do in NABOR to collect all that and give it to them. So make sure you allow, I like to see 10 days for inspections, because if there's a problem with a roof, the inspector is not a licensed roofer. If you need a second opinion or something, you got to give yourself a little time. So when your buyer's saying, well, I'm only gonna put down 5 days for inspection, I want my offer to shine, that can be the buyer shooting themselves in the foot. So don't let that happen. If it's an older home, you may need a second opinion from a plumber, from an electrician, from a licensed roofer, a termite inspector. That stuff, the inspector is there to point out issues. He's not there to tell you that the roof is bad, or that there's active termite damage, or that there's mold, or that, you know, the inspector is a discovery person, not necessarily your final source before asking the seller for repairs. So I think hopefully we stress some of the differences here, and everybody have a great day.
Thank you, Jeff. Have a good day, sir.
Thank you.
you.